Controversy in the court. For today's lesson, we will be examining some of the more controversial aspects of the Supreme Court of the United States, so that you can be aware that our current events issue, it would merely be the first in a long string of sordid tales of vile, downright disgusting elements of the history of the Supreme Court. So let's begin with a basic do now. So, on your guided notes, I want you to answer this question. Should justices be elected? Please provide your opinion and reason. We're going around and I want to hear all opinions. So what you should be looking at is the question of should judges be elected, or should there be another method for choosing judges, such as being appointed? And I want to hear your thoughts on the issue. So, the first thing we want to look at is reversing a Supreme Court decision. So, as you learned last class, as we discussed last class, the purpose of the Supreme Court, the function of the Supreme Court, as per the Marbury versus Madison ruling, is to interpret the law in terms of the Constitution and determine whether or not a current law made by Congress or by the states is in line with the Constitution. Now, once the Supreme Court makes a ruling, it is rarely overturned. In fact, many controversial rulings actually remain on the books as part of U.S. law without any alteration. So some famous examples include the 1944 case of Korematsu versus U.S. Now, Korematsu versus U.S. is the case that legitimized the internment, that is to say the imprisonment, of Japanese Americans under Executive Order 9066. So the background. During the Second World War, in the aftermath of the Japanese Empire's attack on Pearl Harbor, there was a great deal of fear and paranoia in the U.S. about people of Japanese descent, and many individuals within the U.S. questioned that in the event of a Japanese land invasion on the West Coast, would such individuals remain loyal to the United States, or would they defect to the Japanese side? Now, there was really very little proof of any actual mass disloyalty among Japanese Americans, many of whom were second or third generation immigrants. So they, and in many cases their parents, had grown up as United States citizens, and they thought of America as their country. America was legally their country. However, mass paranoia, with a decent helping of racism, prompted President Franklin Delano Roosevelt to issue Executive Order 9066, which called that for individuals of Japanese ancestry on the west coast of the United States to be imprisoned in camps within the interior of the United States. As a result of this ruling, a gentleman by the name of, I believe his name was either Greg or Gary Korematsu, filed a lawsuit against the United States government. It took until 1944, almost the end of the war, before the case appeared before the Supreme Court. In their ruling, the Supreme Court, under Justice Hugo Black, famously struck down Korematsu's objection. Now, Korematsu argued that he was being denied due process, and that his 15th Amendment rights were being infringed because he was being imprisoned wrongfully simply on the basis of his nationality, and had never been given any due process of law to deflect any charges of treason. Nonetheless, Hugo Black argued that in the cases of war, such actions should be allowed, and as a result, Korematsu versus U.S. was passed. Despite controversy and even official government apologies under the Reagan administration, there was never actually any court case that has overturned Korematsu versus the U.S. So it does remain, in effect, a legally binding ruling. A similar case can be said for the 1927 ruling of Buck versus Bell. This case in the South legalized forced sterilization of individuals with disabilities, or even in many cases individuals who had committed crimes or whose parents had committed crimes were forcibly sterilized by various states, and this ruling was held up by the Buck versus Bell case. This one has also never been overturned. So officially speaking, it is still legal in the United States to imprison an entire race of people on suspicion of disloyalty, as per Korematsu versus the U.S., and it is legal to forcibly sterilize people, as per Buck versus Bell. So those two rulings stand. As kind of terrifying as that may sound to a lot of folks, those are still legally binding rulings. So, now, before I scare you into thinking that every idiotic thing the Supreme Court has ever done is now written in stone and America is doomed forever by its past decisions, relax. There are actually ways to reverse a Supreme Court ruling. The problem is they're both very difficult. So the first case is where a second Supreme Court ruling overturns the last. The most famous example of this is when Brown versus Board of Education of Topeka, Kansas, overturned Plessy versus Ferguson. So, for a little review for folks who are a little fuzzy on these two cases, Plessy versus Ferguson was a case in the late 1800s. A gentleman of African-American descent boarded a train car in the Deep South. He purchased a first-class ticket, so he got to sit in the nice car. He had some money. While seated in the car, he is approached by the conductor, who informs him that the car he's in is for white passengers only, and that he has to get up and change seats to one of the cars that is designated for black folks. Enraged, he files a lawsuit against the railroad and against the state, and it reaches all the way up to the Supreme Court, where famously the Supreme Court ruled in the 1800s that segregation based upon race was legal so long as the races remained separate but equal, by which they meant so long as equal facilities were provided for both, you could segregate, you could group people based on race. Now, of course, that's a catchy bit of wording, because how you define equal facilities often had a wide range of interpretation. So, for example, in many cases, this led to scenarios where, whilst facilities would be provided for both black and white patrons, the ones afforded to white patrons would be superior to those conditions afforded to black patrons. So, you'll often see pictures of water fountains as a clear example. You would see fresh, brand new, shiny water fountains that were labeled as white only, while there'd be a much older, less impressive looking model labeled for blacks only. Now, this ruling remained the law of the land until 1956, with the case of Brown versus Board of Education of Kansas. In this famous case, the Supreme Court overturned the early Plessy versus Ferguson ruling, arguing that separation was inherently unequal, and as a result, that struck down Plessy versus Ferguson. Now, the other way in which a Supreme Court ruling might actually be overturned is if the Constitution itself is amended. So if you actually change the Constitution, then you can essentially make a Supreme Court ruling null and void. So a famous example of this is how the 13th and 14th Amendments nullify the Dred Scott versus Sanford case. So, once again, if anyone's a little fuzzy on Dred Scott versus Sanford, it was a case in which a gentleman by the name of Dred Scott, he was a slave. Now, the family that owned him repeatedly moved between slave and free states. When his master died, he filed a lawsuit arguing that since he had spent time in a free state where slavery was illegal, he was in effect a free person and deserved to be liberated. The case made it all the way to the Supreme Court, where the Supreme Court issued what is probably considered one of its darkest rulings. The Supreme Court said that, one, Dred Scott could not even bring a lawsuit because, one, he was not an American citizen, and two, he was not a person, he was property. They then went on to argue that all African folks were not citizens of the United States, and that those held in slavery were property, and then went a step further to argue that since the Constitution forbids anyone to be deprived of their property without due process of law, that slavery was legal throughout the entire United States, and the states no longer had the right to ban it. Consequently, the Civil War occurred not long thereafter. And after the war, the 13th and 14th and also the 15th Amendment are passed. And the 13th Amendment banned slavery and involuntary servitude except as a punishment for a crime. And the 14th Amendment guaranteed, 14th and 15th Amendments guaranteed equal protections under law. So why do I bring these up? Well, by so doing, these cases made African American citizens and made slavery illegal, and in so doing, nullified the conditions under which the Dred Scott ruling was issued. So that's another example of how you negate a constitutional ruling by the Supreme Court. So, some other interesting controversial things about the Supreme Court. One major controversy of the Supreme Court is that there is no enforcement. The Supreme Court cannot actually enforce any decision it makes. It is up to the President and federal and local law enforcement agencies to actually enforce a Supreme Court ruling. A famous example of this is Andrew Jackson when he ignored Worcester versus Georgia, in which it was ruled that the state of Georgia had wrongfully taken land from Native Americans that had been guaranteed to them under a treaty. In spite of the Supreme Court ruling, Andrew Jackson simply moved to ignore it, and the ruling was ignored. Now, most presidents will simply not enforce disliked rulings as strictly. So most won't go as far as Andrew Jackson. They just won't be keeping as tight of an eye on it. So you'll notice, most likely, that civil rights infractions based around certain groups such as blacks, LGBTQ community, will probably not be as strictly enforced under the current administration as they were under the previous administration. Whereas court rulings detailing things like late-term abortions may be more strongly enforced under the current administration than the previous administration. That type of thing. So let's look at packing the courts. This is one of the most interesting things. So courts have what's called judicial inertia, which is that courts are often bastions of old ideas. So older, more conservative individuals, especially the Supreme Court where people reign for life, older folks tend to be judges. So as a result, courts are often one of the slowest aspects of a government to change or get on the bandwagon with a new idea. And so when FDR was trying to pass the New Deal back in the 1930s, he faced heavy opposition from the Supreme Court over the New Deal programs. So this is a famous controversy because he asked Congress for a law allowing him to appoint one new justice for every justice over 80 years old in an effort to pack the court with younger justices. It was not well thought of, and even his Democratic allies deserted him on it. Hence the political cartoon where you see a donkey running away and FDR saying, "All I said was give me 6 more justices." So, some more controversial decisions and people. So, Roe versus Wade, 1973, the case that legalized abortion. People are intensely divided. If you ever want to start a fight, a bar fight, a protest riot, you name it, bring this case up, people will be at each other's throats. It is one of the most contentious rulings in U.S. history because it It legalized abortion, and that's become very controversial.